And I would like to thank and welcome everybody that has registered for today's webinar. It is going to be hosted by Stilus, but it's going to be presented by Kemp and Associates. Elaine Skuman, unfortunately, is not able to present today due to an urgent matter that she has to attend to, but we are pleased to be joined by her colleagues Samantha Bossinger and Stian van Sale. You guys want to just shout out in the background? Hopefully everyone can hear you. Hi, guys. Okay, I'm going to give you a small bio just on Elaine, Samantha, and Stian, and a little bit about Kemp and Associates before I hand the mic over to Samantha. Elaine is one of the directors of Kemp and Associates, Cape Townian born and bred, and grew up in the northern suburbs of Cape Town. Completed her Bachelor of Laws at the University of Stellenbosch. Well, I'm glad it was in 2005 because nobody wants to be anywhere near UCT and Stellenbosch these days. She was admitted as an attorney in conveyance in 2007 and admitted as an attorney with right of appearance in the High Court in 2011 and one of the directors of the firm. After completing articles, Elaine also was a legal advisor with Independent Debt Management Group, where she attended to various debt review matters and other legal work. In addition, she has a postgraduate from Stellenbosch in financial planning, a postgraduate from UCT School of Business in Property Development, and a master's in property. Samantha, who's joining us today instead of Elaine, completed her Bachelor's of Law at the University of Stellenbosch, has been admitted as an attorney in conveyancing in 2013, and has since then been exposed to many aspects of conveyancing, which for those who don't know is property law, including overseeing various types of transactions, transfers, bond registrations, cancellations on behalf of all four major banks. She's now a professional assistant at Kemp & Associates, where she assists Elaine in the conveyancing department and has a keen interest in notarial practice and compliance work. Stian, who's joining us, if you've got any litigious questions, completed his Bachelor's of Law at Stellenbosch as well, after obtaining a Bachelor in Arts. Very interesting, Stian. Stian served as a candidate attorney at Loebsch and Hatting in Belleville, completed his articles, and is now also a professional assistant with Kemp & Associates. Stian attends to general litigation. The Nedbank Collections Department is what you run at the moment. Am I right, Stian? He has extensive knowledge and experience in the following fields: litigation, contracts, family law, collections, legal costs, wills and estates, to name just but a few. He has a keen interest, he tells me, in the wine industry and aims to improve on a field in the liquor law shortly. But I think, Stian, we are talking professionally, your interest in the wine industry, right? At the moment, personally. Just a little bit for everyone's information on Kemp & Associates, just so that you know the firm that's going to be talking to you today, where they come from, what they do. They were established in 1994 as a niche firm of attorneys specializing in litigation, foreclosures, collections, conveyancing, and so forth. They render specialized services in the legal field, ensuring that the client is always the main focus and ensuring service excellence. The firm is committed to Black economic empowerment and promotes BEE bursaries, preferential procurement, training, and social upliftment projects. They are also further a level 1 contributor. When I asked Elaine and the other director, Gustav, what do they think makes them stand out above other firms? And their answer was, we have spent a number of years to ensure that the relationships formed in all areas with various role players in the legal field and the community be of benefit to the company as well as our valued clients. We feel that it is key for any attorney to act professionally, reliably, and specifically quickly in obtaining the required results to ensure that risks are kept at a minimum. Further to the foregoing, we submit that the most important part of acting for a client is to obtain the goal as efficiently as possible with the least financial impact on the client. Our goal is to provide strategic and technical legal advice and add value to our customers by understanding their needs. We take great pride in being able to offer our clients our experience and service of impeccable standards through relationships with role players in the industry. I can definitely attest to this. I mean, I've been dealing with Kemp & Associates for quite some time, and I find Gustav and Elaine lead by example when it comes to honesty and integrity. They have an amazing team of professionals who I'm going to introduce just two of to you shortly, and support staff that assist them in a helpful and professional manner. The firm offers superior service, solid legal advice, and their fees are always reasonable. On your screen, you should be able to see just the front page where we say Stilus and Kemp & Associates. And if any of you cannot see as we're going along, the second slide should show you what we're going to be discussing today. But Kemp & Associates, from family law to property transactions to heavy litigious matters, all is attended to with attention to detail and never detracting from the outstanding customer service. So, without further ado, I'm going to hand you over to Samantha, who is going to chat to us about the amendments to the proposed regulations to the sectional title legislation. For those of you who are trustees and who are owners in sectional title schemes, there's been much debate going on about the proposed regulations. If you're an owner or a trustee in a sectional title scheme, we can assure you these proposals, the proposed regulations, if they should go through, will affect you. I'm going to hand you over to Samantha, who's going to take you through it.
Thank you, Lisa. Good day to everyone out there. If I sound a little nervous, it's just because it's the first time I've presented a seminar without being able to see the audience. But at least the positive for you is that you don't still have to look at my funny face as well today. Today I'll be discussing the legislative framework of the amendments to the regulations of the Sectional Titles Act and the proposed regulations to the Sectional Title Scheme Management Act, as well as the Community Schemes Ombud Service Act. Thereafter, I'll briefly touch on the individual aspects of the legislation which is causing uncertainty in the sphere of sectional titles. When preparing for this webinar, I realized that I was not sure how the aforementioned regulations and acts affected one another. It dawned on me that if I didn't understand the interaction and was a practicing conveyancer, I could imagine the confusion for role players in this specialized industry. The amendments of the regulations to the Sectional Title Act have been effective since 1st of August 2015. The prescribed management rules contained in Annexures 8 to the regulations, and specifically prescribed management rules number 7, 70, and 15, sub-rule 5, have been amended. In addition to these amendments, the legislator has included sub-rule 4, capital A, small a, under prescribed management rule 31. On the other hand, we have the Sectional Title Scheme Management Act and the Community Schemes Ombud Service Act, which have been signed into law, but neither act is yet in operation. The acts will, however, come into operation once the regulations constituted in terms of the act have been enacted on a date to be proclaimed by the President in the Government Gazette. The regulations of the Sectional Title Scheme Management Act essentially contain the amended version of the prescribed rules regarding the management of a sectional title scheme, which is currently governed by the regulations of the Sectional Titles Act, which you all know. The aim of the Community Schemes Ombud Service Act is the establishment of an ombud service which functions to include establishing and maintaining a dispute resolution service, training stakeholders, and checking, holding, and providing access to scheme governance documentation. The proposed regulations are aimed at the administration and financing of the Ombud service. So first we're going to start talking about the amendments to the regulations of the Sectional Titles Act, which have been construed as grey areas for owners and trustees. So we're going to start with Prescribed Management Rule 31, Sub-Rule 4A, which was removed from the regulations to the Sectional Titles Act in 2013. And this rule required owners to continue paying their contributions in the same amounts as they were paid during the expired financial year. The rule also gave trustees the authority at the end of the financial year to increase contributions by up to 10% to take into account expected higher liabilities. This enabled the body corporate to raise income in the period between the end of the financial year and the date of the annual general meeting. The implication of the removal of Prescribed Management Rule 31, Sub-Rule 4A, is that it removed the obligation on owners to pay levies once the financial year had ended. Furthermore, the trustees could not increase levies until the annual general meeting took place. In the amendments to the regulations of the Sectional Titles Act, the legislator included this prescribed management rule again, but changed the wording thereof. It is now referred to as Prescribed Management Rule 31, Sub-Rule 4, capital A, small a. The consequence of the change in the wording creates uncertainty as to the meaning of the rule and could create disputes. One interpretation could be that the trustees can increase the levies by up to 10% in order to cover operating or running expenses. However, one could also interpret the rule to mean that the cap of 10% applies only to operating expenses, whereas trustees can increase levies by any amount in order to cover capital expenditure. And that is a direct quote, capital expenditure. What they don't do is define the term capital expenditure in the legislation. And this leads to more uncertainty with regards to the meaning of the rule. We will only be able to give certainty to this rule once a court has interpreted it. So we're going to move on to the next prescribed management rule that was amended, and that is Rule 15.5, which stated that an owner was entitled to attend and speak at a meeting of the trustees of the scheme, but the owner could not vote at the meeting. The rule now reads, an owner shall be entitled to attend on invitation any meeting of the trustees, but shall not, in his or her capacity as such, be entitled to vote thereat. The amendment means that the owner is no longer entitled to attend the meetings without invitation. Furthermore, the removal of the phrase, and I quote, and speak, could also mean that even where an owner is invited to the meeting, he or she may not speak at the meetings. So you'll see my next slide is a little joke, but they're trying not to be exclusive, but you're not invited. Trustees have the authority to make important decisions without seeking a mandate from the owners, and owners often attend trustees meetings so they can monitor how trustees are managing the body corporate's money and property. This creates a sense of accountability to the owners. However, owners will no longer be able to do this unless they are invited. The rule also omits who has to extend the invitation to the owner. Role players have pointed out that this amendment infringes on owners' rights in that trustees may make decisions without regard for the interests of their owners. The practical implication is that owners will only be able to participate in any scheme administration during the annual general meeting. So I'm going to move on to the next two amendments and cover them briefly. The first one, these two deal with the exclusive use areas and the nomination of trustees. So in terms of the amendment in Prescribed Management Rule 70, you'll see that an owner must adequately maintain any improvement to his or her exclusive area, and if they fail to do so for 30 days after being warned to do so by the trustees, the body corporate can carry out the maintenance itself and recover the costs for the owner. This, on the other hand, is contrary to Section 44 of the Act. The Sectional Title Act imposes an obligation on an owner to keep his or her exclusive use area in a clean and neat condition. But it is the responsibility of the body corporate to maintain exclusive use areas and to require owners with exclusive use rights to make contributions to the costs it incurs in this regard. The implication of the amendment is that the amended rule is in conflict with the Sectional Titles Act. There is no certainty as to where the obligation lies now. But in light of the fact that a prescribed management rule cannot replace or amend a statutory obligation, it would be safe to say that the obligation will remain with the trustees until the Sectional Titles Act has been amended. Then Prescribed Management Rule 7 was also amended to exclude owners whose levies are in arrears or has breached the scheme's conduct rules from being nominated as a trustee or nominating a trustee at the annual general meeting. I think that's pretty straightforward. They are expressly excluded from being trustees. So we're going to move on to the regulations of the Sectional Title Scheme Management Act. The first proposed regulation in terms of this act is that the body corporate must establish and maintain a reserve fund in such amounts as are reasonably sufficient to cover the cost of future maintenance and repair of common property, but not less than such amounts as may be prescribed by the Minister of Human Settlements. It is not yet certain how these reserve amounts will be calculated. And the practical implication of this regulation is that the body corporate has to establish two funds, an administrative fund and a reserve fund. Levies collected from owners must be paid into the administrative fund and used only to fund operating expenses in the current financial year. A portion of the levies collected must also be allocated to the reserve fund and used to pay for future expenditure determined by a maintenance, repair and replacement plan, which the body corporate is now required to draft. The draft regulations goes further by stipulating the formula that a body corporate must use to determine the minimum allocation to the reserve fund when it draws up its annual budget. However, it doesn't stipulate that the formula does not apply to new schemes when the first budget is presented at its first annual general meeting. I'm going to move on to the next proposal and to say the draft management rule that has by far caused the concern for bodies corporate is the restriction on the interest that they can charge owners who default on their levies. Now, we know that it affects most of you listening at the moment, and whether you're an owner or trustee, it's going to affect you. As it stands, a body corporate is able to decide on the interest on arrear levies. That's exactly how it is. You decide what levies it is. What the interest is, and that's how you charge them a penalty interest. It's supposed to be punitive. So the proposed regulation states that the rate may not exceed the maximum rate of interest a year under the prescribed rate of interest act. And this amount is compounded monthly in arrears. The practical implication is that should the draft regulation be in effect right now today, the interest charged on arrear levies would only be 9%. There are contrasting opinions with regard to this amendment. Experts in the sectional title sphere feel that restriction on the interest rates charged on arrear levies will encourage non-payment of levies because it won't be seen as a punitive measure, and that the restriction places this restriction will have a negative impact on the market. The additional amount of levies, which is required to be contributed by the owners to cover the reserve fund, will also be an onerous burden. The majority of schemes keep their levies low by making little provision for future expenditure in their budget. Oh, sorry. I must actually apologize, guys. Sorry. This is something that I missed. Sorry. I'm going to go back to the previous Sectional Title Scheme Management Act proposal. It's with regard to the levies that must be paid into the administrative fund and the reserve fund. What I wanted to say there, and I skipped it completely, so I must apologize. The additional amount of levies which you're going to have to charge to the tenants to make up for the reserve fund and the contribution to the administrative fund will create an onerous burden on the owner. And I wanted to say that most schemes generally keep their levies low by making very little provision for future expenditure in their budgets. So they would rather impose a special levy to raise funds should they have a major expense that they had not foreseen than have a reserve fund. So on the other hand, I can also say that practice has also shown that when they do make their budget, they are quite conservative. So, that's why the special levies really worked at that time. So I'm going to move on, but I'm going to touch on the draft regulation with regards to the the reserve fund again. I have a question from Yvonne, and I will touch on the practical side then. Okay, so I discussed the aim of the Community Scheme Ombud Service Act earlier. The primary concern of bodies corporate in relation to the regulations is the contributions that are required to be paid to the Ombud Service annually. And it must be paid annually on the 30th of September. Well, before on the 30th of September. These amounts are still to be determined by the Minister of Human Settlements, and there's definitely uncertainty with regard to the contributions. You could think if you need to make a budget, you're not going to know what you must contribute yet. Further to this, should the body corporate fail to pay a levy or other amount due on the date that the amount is due and payable, the Ombud Service is entitled to charge interest on that amount for the period it remains outstanding at a rate which is 1% higher than the service's primary banker's prime lending rate, compounded monthly in arrears. The implication is that the Ombud Service will be able to charge the prime interest rate plus 1% on outstanding levies, and you're charging your client on arrear levies 9%. One must question how these rates are determined, taking into account that current bodies corporate may only charge these rates, the arrears rate at 9%, and they can charge 10.5% interest on your overdue levies. That's just a summary of the regulations, and we're going to be taking some questions soon, but I have put a slide up saying where you can email your comments to, and it must be submitted by the 1st of November. And then if you see there's a next slide, There's the invitation, the official invitation to attend the public participation session. We're in Cape Town. We'll be there on the 29th of October. I know Lisa's going to be there as well. And that's pretty much my presentation. We're going to be taking a few questions in the next few minutes, but I want to deal with Yvonne Vessel's questions. She emailed them through to us today before the session. So her first question is, when does the proposed amendments to the Act come into effect? Now, as said before, the Sectional Title Act amendments are already in force. It was in force since the 1st of August. And the other regulations which they're proposing with regard to the Sectional Title Schemes Management Act and the Community Schemes Ombud Service Act will only be become law or be enforced once those regulations have been enacted and once the President has proclaimed the date that it will be enacted. It could be any day after the 1st of November, pretty much. Then she asked another question. If your reserve fund currently is more than 25% of your new budget, do you still have to add the 25% to your budget figure? Now, it depends what you, I've considered the question and I look at when you say your new budget, it depends on what you're referring to. Your budget will now have to consist of contributions to the administrative fund and to the reserve fund. So if you're saying your new budget, if you look at the definition of the Act, and this is where I said I'll touch on again, the formula is based on the amount in the reserve fund at the end of a financial year and the total contributions collected in that year. So in this case, if at the end of the financial year, the money in the reserve fund is more than 25%, but less than 100% of the total contributions to the administrative fund, and this is where the difference is. The administrative fund for that year, the contribution to the reserve fund must at least equal the amount of the body corporate budget spent from the administrative fund on repairs and maintenance in the coming year. Now, it is a bit verbose. Even I struggle to understand it a little bit. But that is pretty much simplified version out of the Act. Okay, then you'll see also that the formula has got 3 legs basically. If at the end of a financial year the money in the reserve fund is less than 25% of the total contributions to the administrative fund for that year, then in the next financial year the minimum allocation to the reserve must be 15% of the contributions to the administrative fund. Now I think that's pretty clear. And then the other leg is, of course, at the end of the financial year, the money in the reserve fund is equal to or more than 100% of the total contributions to the administrative fund for that year. The body corporate doesn't have to top up its reserve fund because the funds are there. Then we've got quite a few questions from Yvonne. So I'm going to not deal with all of them, but most of them. She asked, who will control the 10-year maintenance plan to ensure it is in place? Now, I've gone to look at section 22.4 of the Sectional Title Schemes Management Act. Sorry. And according to that, it says that this maintenance plan must be approved by the members in the AGM, number 1. And number 2, they will see to it themselves that the report is up to date and being maintained at the annual general meeting. So, this is really placing a burden on the body's corporate, and no one's actually going to be overseeing these plans or to see that they are, accountable for it. And then we've got another question. She says, currently we charge interest on late payment of levies, i.e. prime rate plus 2.5%. As per the article of Tertius Maria mentioned, as per the article of Tertius Maria, he mentioned that that it should not exceed prime plus 1%. Sorry, this question's a bit confusing. That's fine. It's not, the prime plus 1% is applicable to should your levies payable to the ombud service be outstanding and in arrears. With regards to the actual arrear levies, you can charge only the rate in the Act, which is 9% currently. So that would have to be adjusted immediately. Okay, so we're quickly gonna. Sure. Okay. Well, Yvonne, I'll tell you what. I think Lisa said that we're taking a bit longer at the moment than we planned. So I'm going to email you the answers on the rest of your questions, and then we take it from there. But I've got your email address, and I hope you guys have a good day, and we'll answer some more questions hopefully.
Thanks, Samantha. Thanks very, very much. It was very informative. I'm going to unmute your mics. I see, Nikki, you did have a question mark there earlier. If you have any questions, I see Clinton May, you've pushed something over there as well. I'm going to just let me know when your microphones are unmuted. If there's anybody that has a question that they would like to ask. Let me see. Where's Nikki? Nikki, are you there? Let me just find you. You just mute all. Let's unmute all. Let me just find Nikki here quickly. Hold on a second for me. There we go. Nikki, can you hear me?
Okay.
Yes. Hi, Nikki. Are you there?
Yeah.
I see that you had a question mark. I think you clicked one of the icons. Did you have a question that you wanted to ask, Samantha? Or do you have any comments on the proposals?
No, I'm good for now.
Are you good for now?
I thought I had a question and she
And then she answered it. Okay, no, that's perfect. Just bear in mind the regulations are just merely proposals at the moment. The public does have up until the 2nd of November to lodge any objections, any recommendations. If you are in Cape Town, you've got until the 29th to go to the public participation seminar. It's going to be held at the Cape Town Lodge. And I'm putting back on the screen for everyone to have a look. Depending on which area you are in, there are the dates. And so please do take note if you want to participate. Should you have any other queries or any other questions that you want to either send through to Stilus or through to Elaine and Samantha with regards to the regulations or the Sectional Title Act as it is at the moment, just remember that everything is very much up in the air at the moment. Nothing has been finalized. These are proposed regulations. And the reason we have Samantha here today is just to make trustees and owners aware of where the Act stands at the moment and what the proposed changes could be. So whether those changes are going to come into place or not, we don't yet know, but those changes from what we've seen just briefly are going to be significant, especially if you look at if you don't make payment to the Ombud service, it's going to be charged at prime plus 1, where you can only charge your owner's arrears levies at 9%, where now you have, if it comes into play, you can only be invited by the chairman to a trustee meeting, but you may not speak. But those things are not defined. So it does help to come through to this for what it's worth. If you're in Cape Town on the 29th, please do attend. But seeing as we've got two attorneys here who are offering some pro bono work for the day, I know Stian needs to bring up his pro bono hours. If there's anyone there, you don't have to ask your questions now. But do note that you can, I'll put up on the next screen the contact details. There's Elaine's email address, but you can also reach them through their website. There's a telephone number. The firm covers a number of different aspects other than just conveyancing. As I mentioned, there's litigation, there's civil, there's criminal. So if you get caught drunk and driving this weekend, you can definitely give Stian a call, seeing as he has the interest in the wine industry and he can help you from a criminal point of view. Guys, I hope you found today's session informative. Please, not to sound like a stuck record, but if you do have any questions, please feel free to email them through either to me directly, and I will gladly forward them on to Kemp and Associates. And Yvonne, your questions, we do have them on email, and I know Samantha and Elaine will attend to them and actually mail you personally with answers to yours. If there are any questions before we sign off for today, anybody at all? I see everybody's on lunch. It's 1 o'clock now. Okay. No, well, that's fine. For those who are still tuned in, thank you very much for your time and for joining us. I'm going to be sending out an email at some point just to find out your feedback on today's webinar, whether you found it useful, whether perhaps you'd like to hear from Kemp and Associates on different topics, whether they can chat to you about estate planning or how to get divorced or what to do before you get married and all those sorts of fantastic things that life throws at us. Please do let us know and I will forward that on to them as well. But from me here at Stilus, and a big thank you to Samantha and Stian from Kemp and Associates, wishing you all a fabulous Thursday. Until next time. Thanks very much, guys. Enjoy the day. Bye.